Okay, we are at week 10, and this is the very last lecture for J150 Introduction to Criminal Law. And so we're going to go through a few things, and then I'm going to go and do the lecture. So this is it. This is the final one. So let me start by sharing my screen. Okay, and so as you can see, this is a familiar page to you. It tells you my information, tells you my communication, methods to reach out to me, with the reminder that from day one I've expressed an open door policy for reaching out to me by text, email, phone, any hour of the day. I've also reminded you on the additional course page that you have to conduct research for all papers. That means that your sources need to be other than those of the textbook. And if you don't, I tell you, you will lose 2 points. Some students have wondered where they get that from. I said it's here, and it's also in the syllabus. And then I also have stressed the importance of APA, meaning that citations in the body of the paper, and by the way, citations should be throughout the paper. There are statements that I read in papers that students submit, and those statements are informational, but there's no citation giving credit to where the source of that information came from, even if you paraphrased it. And so a paper, in most of our papers, are 2 pages long. There's only one assignment that has a 1-page paper, but most of the assignments, both the written assignment and the projects, are 2 pages long. So there should be citations throughout the body of the paper, and they should be proper. If there's a case involved, then you should give the entire case citation. And then, of course, at the end, references. Now, the references should match what's in the paper, the citations. I've seen times when students give me references, and they'll mention one of the citations from the reference sheet. All of them should be utilized in your paper as citations and should be reflected as such. So again, this gives the schedule of our live lectures that we've had this year, this quarter. And so starting with week 2 and all the way through to today. And so now let's take a look at our announcement. What to expect before and during the trial. There are things that take place before trials that are important, and we're going to go over some of those things in just a few minutes. So we're going to cover chapter 17 and 18. I already sent you the PowerPoints for that as well. And then take a look at the pre-trial and trial expectations. And then reminder of discussion posts that are due tonight at 11:59 p.m. Central Standard Time on jury selection and voir dire. And then Saturday, 11:59 p.m. Central Standard Time, your posts are due. Now, finally, plea bargains is your written assignment. Again, it specifies how many pages, and it is 2 pages, as I said, with citations and references referring to this portion right here. And that's due on Sunday. And then your quiz, your 10 questions, which you have 10 minutes to complete. And then finally, your project, filing pretrial motions. And these are some of the things we'll be talking about tonight during tonight's lecture. Okay. And then, as I said already, finish strong, start strong, and finish strong. And then my motto. So let's take a quick look at the course calendar. Okay, just a second here. Here we go. And we are right here at week 10. and it gives all the information I just covered a few minutes ago. It gives you the dates that those things are due, the quiz, the course project. And so now, while I'm looking at this, there is no lecture next week. This is it, reminding you that your initial post will be due a week from today for chapter 11. For week 11, and your reply post will be due. Everything else will be due that Friday, the 17th, and all assignments that are due. Normally, again, this is the last Sunday in week 10 that you have. After that week 11, it's all loaded into Friday, okay? And then there's a reminder. And, students say, oh, I didn't know the quarter was going to end. I says, not only will you see that in your announcement next week, but you will also see a reminder in your calendar that reminds you of that as well. So there's no reason why a student can come forward and say, I wasn't aware of that. My professor didn't let me know. Not going to fly, because since day one, this calendar has been put together. I haven't really made any changes to it as well. So it tells you what assignments are due. And just to give you a peek, I'm going to show you what I'm talking about, just so you'll see, giving you a peek at week 11. You can't see it yet, but I'm telling you what it says. Notice it tells you your assignments, but it tells you the 17th. But look at what I have in yellow highlighted in all caps, a reminder. The quarter officially ends at 11:59 p.m. St. Patrick's Day, the 17th. So don't go out celebrating. Get your work in. After that, I'm not going to be able to grade it. I'm not going to give you an opportunity to get it in later, even if I'm still grading, because my grades are going to be due that following Monday for every one of my 5 classes. So the heads up, just so you'll know, all right? So don't say, oh, I didn't know. No, here's the information to make sure. I am one of the most informative professors that you're ever going to have. I will make sure that you get the information completely at the time. So now let's go back and let's take a look at, forgive me for that bell, keep hitting that little button. Let's go to Module 10, and let's look at the assignments again, reminding you of what the requirements are. Read the assignment. See, it says 2 to 3 page paper, and you got to make sure you address these issues using these facts, okay? Make sure you have a cover sheet and you know the rest, references, citations. Your discussion posts that are due, we've already talked about that. And then your project is also a 2 to 3 page paper, and you want to make sure that you have citations and references in that as well. You recall at the beginning of the quarter, I gave you a rubric that covers how many points you can lose for not having citations, references, or the number of pages for both written assignments and for projects. And then finally, your quiz. So those are the things that you have. Many of the classes have final exams. You don't, because basically you're taking your final exam over every week with the 10 questions. So basically you will have covered 110 questions by the time you get to week 11 and completed it, rather than to have one test that has 50 questions and another have 50 or 60 questions. So the point of the matter is the way this is laid out, it kind of gives you an advantage, because you don't have to load all this information into the brain for the other weeks that you have. So you get finished with a week, you're done with it. Okay? So now let's go back. Let's look at the lesson content before we get into the lecture. Of course, our objectives are clear. We're going to talk about pretrial, and we're going to talk about various motions, jury trials, and all the different phases of a trial. And we're going to explain some of the constitutional procedures that are involved with that. Again, here laid out again is your expectations of work for this week, okay, which we've already gone over. So now, this explains pretrial motions, and we're going to talk about that in the lectures, but you can get a foretaste of it just by looking and reading this. What is a motion to dismiss? What's the motion to suppress physical evidence? Motion to disclose a confidential informant. What is plea bargaining, which we're going to be discussing that in a little more detail in just a few. And then the right to a jury trial, a Sixth Amendment right of the Constitution. And then you go and you take a look at these flashcards that you have here. And it answers the question, what is an arraignment? And then it tells you at the top, an appearance before a court of law for the purpose of a criminal charge. And then if you flip this over, you'll see that basically. Then you go to the next one. What's pro se? Representing yourself. Then you flip that over, and then you go to the next one. What is bail bond? Money, a sum of money posted to ensure the appearance of an individual in court. And you flip that over. And then, okay, you go to the next one. What's a subpoena? An order issued by the court for attendance. There's also a document, there's also a subpoena called a subpoena ducis tecum, which says not only do you come, but you also bring any pertinent documents that pertain to the action as well. But this subpoena is for the person only. Okay. Information. See, we're talking about a term of art here, information. A document that is filed by the prosecutor under oath, charging one or more persons with the commission of a crime. That's an information, okay? Pretty much the same as an indictment, but there's a different process. But speedy trial. There are various jurisdictions. We're going to talk about that as well. The right to an open public trial conducted without unreasonable delay. The only difference from this, the speedy trial, is that juveniles don't have open public because there's a different process that takes place there. But in adult court, it's open to the public. Sometimes people say, well, I couldn't get in. That's because the courtroom was already full. Okay. Standby counsel. When a person decides to represent themselves, sometimes the court appoints what we call standby counsel to help them. Usually that will occur in a case where a person has a serious offense and the individual stands jail time, or in the case of the death penalty, there is always standby counsel because the individuals have a right to represent themselves. However, they don't know all the procedures that are involved there. And so as a result, counsel is appointed by the court to look out for their constitutional rights. A bench trial, that's when the judge is the trier of fact as opposed to a jury trial. Voir dire, which means literally to speak the truth, is the process by which jurors are selected, and questions are asked to the jurors about, their propensity to prejudge or those kinds of things. Usually, in most jurisdictions, there's a card that they give to us as attorneys that the individuals have filled out before the trial, and it tells us information so that we can posit questions to determine to use our what we call Peremptory challenges, that's a certain number of legal challenges to a person that we can just say, hey, we don't want that person. However, peremptory challenges should not be used to stack a jury by race. That's been known to happen, but if it's identified that that's the thing that the attorney will do, it could result in a pretrial motion for dismissal of that jury, or it could result in a reversal in a case where a person is found guilty. Okay. Peremptory challenge, that's what I was talking about a few minutes ago. You don't have to give a reason for it. Then there are what we call challenges for cause. Challenges for cause is when you don't use your peremptory, when a person, like, for example, openly says, let's say, for example, it's a case involving a defendant who is black, and one of the jurors says, I don't like blacks. Well, that person could probably be dismissed for cause because of the fact that they've indicated some possible discriminatory actions, regardless of what the facts may prove. And that's the end of that. Okay, so those are some of the things that you look at. So now I'm going to go into our lecture. It's about almost 8:45, and I'm going to try to be through by 10 o'clock because I'm covering 2 sessions, so that's 2 chapters. So, since there are no students present, I'm just going to go through relatively fast and elaborate on what's on the PowerPoints, because you can read the PowerPoints yourself, but I want to just elaborate on them for you, okay? So every person is entitled to what we call due process of law. And what that very simply means is that you have an opportunity to have notice and an opportunity to prepare a defense or to respond to the allegations and charges that you have. And that means that so that you're not just charged and incarcerated. And so due process is a fundamental constitutional right that is guaranteed to all individuals in our criminal courts. So that's why you'll have a fair notice, you'll have an opportunity to have someone to represent you, or you'll have the time to be able to prepare an adequate defense. And the steps that take place are what we call the initial appearance. The initial appearance takes place with you first showing up in court, your preliminary hearing, and then grand jury proceedings. Now, there are times when the grand jury proceedings supersede the preliminary hearing. We, as defense attorneys, don't like that because what it does is it gives the prosecution a chance to return an information, or what we call a true bill, where the jury votes as a majority, not unanimous, as a majority, that the state presents adequate evidence to take the case to trial. And so when that happens, then in that particular point, then that individual then is brought before the court, and then there's arraignment that takes place. The purpose of arraignment is to just say 2 things, one of 2 things, and the answer is guilty or not guilty. If any of you saw the movie My Cousin Vinny, you saw an example where his attorney came before, played by Joe Pesci, and started trying to explain the charges at the arraignment, and the judge says, no, Mr. Gambino, there's only 1 or 2 answers I want from you, either guilty or not guilty, one or the other. And that's what happens at the arraignment. And that doesn't necessarily mean if you plead, well, if you plead guilty, well, that means then you go right to, you bypass the hearing and you go right to working out a deal or something like that. If, in most cases, they're at arraignment, it's not guilty. Even if you know you're guilty, you're still going to, at that particular point, say that not guilty in arraignment, okay? It won't be held against you later if you change your mind. You have a right to counsel. The Sixth Amendment of the Constitution says that you have a right to counsel. Gideon versus Wainwright is one of our leading cases. Escobedo versus Illinois is another U.S. Supreme Court case that says you have a right to an attorney if you can't afford one, want to be provided for you. Of course, you're familiar with that as a part of the Miranda warnings as well. So you have a right to an attorney, and it extends to all federal prosecutions, including treason, felony, and misdemeanor cases. Now, it extends to cases, misdemeanor cases, where you stand a chance of going to jail. Again, I've said before, what's the difference in a felony and a misdemeanor? It is the sentence. If you are standing a chance of being incarcerated for up to a year, it's a misdemeanor. If it's a year or more, it's a felony. That's how you know. And most states, it says, allow in all state criminal prosecutions, and that's pretty standard. Again, you could still represent yourself, but you have that constitutional right. And as I've mentioned to you, Gideon versus Wainwright, the leading case in '63, where and there's a great movie that I have called Gideon's Army, and I have presented that movie before when I was doing this residentially. I have the video, and then there is also a book that I use in one of my classes that I teach as well. But in this case, this 51-year-old requested a lawyer, and he was charged with breaking and entering, which was a felony. The court said no, and he was convicted. The Supreme Court established from that point on that the right of one charged with a crime to counsel, charged with a crime to counsel, may not be deemed fundamental in some jurisdictions or some countries, but it is ours. So it's a fundamental right. Okay. Scott versus Illinois, this was the other case I was talking about. The Supreme Court ruled that no indigent defendant can be sentenced to a prison term without providing counsel. So if it's a prison term, the court held that counsel is not required to be provided if the defendant does not receive a prison term. But if a prison term is, okay, because this person was convicted of shoplifting and only fined $50, he was denied. Well, he can't be necessarily required to have an attorney. However, you should be aware that because of the fact that even if he was convicted of shoplifting and fined $50, if it's a misdemeanor that subjected him to prison or to jail for a period of time up to a year, then he would have a right to counsel in that instance. The key is if it's a offense that is a possible sentence of any kind of incarceration, then in that instance, then you have it will appoint an attorney if you can't afford one. Usually it's a public defender. And then here's some right to counsel cases in which the Supreme Court held a defendant has a right to effective counsel. Now, what is effective counsel? It's relative. However, though, it's pretty clear that when you have effective counsel, you have someone who is adequately prepared, has done their work, they are knowledgeable about the area. You don't have a real estate attorney who does not know criminal law to represent you in criminal court. You just don't do that, okay, and vice versa. So if, for example, a defendant, it says here, is inebriated or drunk, sleeps through the trial, or is otherwise incompetent or is ill-prepared, that opens up the possibility that a Strickland defense can come about because of ineffective assistance of counsel. It is really stringent in death penalty cases, and obviously you know why, because of the fact that death is so final. And so effective assistance of counsel is probably one of the easiest things to see. Now, I'm familiar with a case of a person who had a lead attorney, this attorney, it was actually People versus Peterson. There was a police officer here in our area, in our jurisdiction here in Illinois, who was charged with killing his wife, or his ex-wife. And so anyway, what the attorney that represented him did was took him out on the media and was working with him to do a book deal, put him all out on all the national shows. He was on AM America at that time, which was on then, and all the different shows, NBC. He was on every station. He was on radio, and he did a lot of different things. Well, one of the things that came about later, and then also his attorney called witnesses that backfired, and most of us as defense attorneys would never have called those parties. Well, one of the things that he tried to argue on appeal was that he had ineffective assistance of counsel. However, the court wouldn't buy it, and there are two reasons why the court wouldn't buy it. Number one, because of the status that that individual was. He was a Drew Peterson was his name, was a sergeant and had a long time experience in the criminal law field. And also that he did this understanding the possible consequences because he knew how the system worked. But here's the other kicker. He had other attorneys who didn't provide that advice, and he went with the lead attorney's advice. Therefore, the point of the matter is that he did have effective assistance of counsel, even if he did have one who was not. So it's something that is pretty, you almost know it when you see it. The results are pretty clear, and so as a result, and then some people say, well, wait a minute. If they go through the trial and they see this person not doing this, then did they waive that? No, because your hands are tied. That's your attorney. That's who's representing. You're presuming that that attorney is licensed and competent. Now, they could be licensed but not competent as well. And if they're not competent, then you might have an effective assistance of counsel argument. So that's kind of like how that works. Petty offenses. Petty offenses are citations to appear in court like traffic tickets, minor offenses, and usually the law permits or requires police officers to issue the citations instead of arresting you, and you go to traffic court or some other minor offenses. Summary trials take place to determine innocence or guilt for those minor offenses. There pretty much are fines that are the disposition of those. So one of the things that happens is when you come before the court in your initial appearance is that the charges are read, you're informed of your rights, and then there is an opportunity for release or detention. Pretrial release generally comes in the form of bail bonds or bail. And bail can operate in a number of ways. The traditional bail that we have in our jurisdiction in Illinois is, let's say if the bail is $100,000, you post 10% of that in property or money. And the purpose for that bail is to guarantee the release of those individuals. If a person does not appear, whoever posted the money will lose that money and or property, whichever. And so that's the traditional way. There's some things are being worked on now by, like for example, we have a state's attorney in Cook County that is working very well to help people who are indigent, who need to get out. The jails are overcrowded. And then number two, there are people who are in there for minor offenses that are still sent them to jail, but for misdemeanor, but they're exposed to hardcore criminals, and they're either attacked or either they're not violent offenders. So therefore, and they can't afford to post bail, so they are working now to get I bonds or recognizance bond. That's what we call an I bond. Now, the I is not it's EYE, but it's I, the letter I, bond. But it's a recognizance bond. In other words, people are granted those when it appears that you're not a threat to the community, it's not a serious offense, and that you will probably, you have ties to the community, you're going to probably appear in court rather than not. Release to the custody of another person, that happens primarily in our jurisdiction. It happens with juveniles, but you can be released to the custody of another individual person. And then posting bond, I explained it. Bail can be excessive. Now, be aware of this, that the Constitution does not guarantee bail. Get this in your head. It says that there should not be excessive bail, and we're going to elaborate on that in a few minutes. It says can be excessive. Well, it should be cannot be excessive. It should not be excessive. And then pretrial detention. Then if there's pretrial detention, then you're held in custody in the jail until your trial. Now, this goes to what I was talking about a minute ago in the Stack case. It goes into 1951, Stack versus Boyle, in which the Supreme Court held that setting bail higher than necessary to assure the appearance is excessive under the 8th, and it says 8th, but it's 8th Amendment. And so as a result, the bail shouldn't be higher than what it takes for an individual to appear. This person was charged with subversive activities in Alien Registration Act. So the bail was set from $2,500 to $100,000, but later was reduced to $50,000 for everybody. Well, one of the defendants, Stack, moved to have the bail reduced, but it was denied. The Supreme Court said, Stack, you're right, that $50,000 was excessive under the circumstances because this wasn't a violent offense. This was an offense that you violated a registration law. And so as a result, his bail would be reduced, and it should not be excessive. Now, let's talk about this one. The United States Supreme Court in the Salerno case in '87 says that there is no constitutional right to bail. I already told you that. Now, here's what happened in this case. This was a mob person. Salerno was denied bail because he was a member of a crime family, mob, and a threat to the community. I don't have to elaborate on that. Salerno appealed, saying that it's unconstitutional to punish him for things that might happen in the future. The court says, no. He says this individual was a known mafia member, and therefore he is not entitled to bail because it's a danger to the community, and there's a possibility that he can flee. So as a result, bail is denied in those situations. So it doesn't just apply to those, but it applies to other offenses. There are murder cases where bail is granted. I just saw recently where a police officer is charged with murder, and as a result, they issued bail, a very high bail, but they also put a monitor on him and put him under house arrest. As a result, he didn't stay in jail, but he's at home. But there are all kinds of conditions that take place. The key thing to remember, guys, is that if the offense is one that is serious, or you're a threat to community, or you are in a position where you can likely flee, or you would have the propensity or tendency to flee, then bail will probably not be granted. Okay, bringing 4 more charges. There are subpoenas issued, and I already talked about what a subpoena is, guaranteeing the appearance of witnesses, of individuals. The defendant is not subpoenaed, but who is subpoenaed are witnesses for the defendant, witnesses for the prosecution, and so forth. In terms of determining what charges to bring, the prosecutors have broad discretion. they can determine whether or not they're going to charge a defendant, and if so, what charges to bring forth. Prosecutors generally have immunity from damages for deprivation of defendant's constitutional right. Now, there are some arguments in cases where the prosecutor knowingly brought charges that they knew were false or had knowledge of in their possession and is discovered later. Then in that case, there is no immunity. Immunity applies in the normal cause of an action where a person is mistaken as the wrong person without sufficient evidence at the time to recognize that was the wrong person. The information, as I said earlier, determines the efficiency of the evidence, and then I talked about preliminary hearings already. The Supreme Court held in the Armstrong case that to establish prosecutorial discretion on the basis of race, the defendant has the burden of proving that similarly situated individuals were not prosecuted. And so what this person argued is that he was discriminated against because he was African American and was charged with using crack cocaine. Well, he would have the burden of proving that prosecutors never indicted or charged a white or Caucasian for the same charges, which is a pretty tough burden to overcome. The grand jury, I talked about that, obtains, as I said, what we call a true bill, and the size of the grand jury varies based on jurisdiction, but I said that a majority agrees on the charges. Now, potential jurors in the grand jury may not be excluded based on race or gender, and it acts as a shield and a sword. And so what it means is that these individuals who are brought before the grand jury, it's in private. As again, the prosecution presents the case and the evidence. Witnesses are protected by the Fifth Amendment. Witnesses do not have the right to counsel there. And then if there is a vote, then a true bill and an indictment is issued, and that person is brought in for arraignment. We don't like it because we don't, as defense attorneys, when I was defense attorney, said that we always argued that it violated the right to a preliminary hearing in which we have a chance to possibly negate the charges and get them ended at the preliminary stage. Well, the Supreme Court held that witnesses may not refuse to testify in front of grand jury, and this is a case we don't like, based on argument that the evidence obtained was based on illegal search and seizure. So in the grand jury, basically what it says is that information that would normally be denied at trial is allowed at the grand jury. So what happens is if there's evidence that we determine is not allowed, we as attorneys, and you'll hear me talk about this in the second half here, that we file a motion to suppress the evidence, to eliminate the evidence from being used against that individual. Well, at this juncture, the court says it's okay, which we scratch our heads on. But anyway, it's still good law. I remember when I was in law school and we read this in my first year of law school, 75. The case was about a year old, and we all queried the professor about that. But anyway, here's the deal. So this person was called in front of the grand jury to testify about loan sharking and evidence that had been found in his apartment. Well, Calandra took the Fifth, which he had a right, and moved to suppress the evidence, stating that the evidence was obtained illegally. He would be right if it was the trial. But the court said, stating that the exclusionary rule does not apply in grand jury proceedings. The reason they said that, and they went on to elaborate, is that the grand jury is not a part of the process that puts you in jeopardy. It is an investigatory tool that is continuing. Again, we still don't buy it. We're fighting with a short stick, and we continue to lose on that. So not going anywhere as far as I can see. Still, whether we think it's fair or not, it makes you scratch your head. But the key defense that the court said in their ruling was it was an investigatory tool. So you can investigate with illegally seized evidence, but you can't prosecute with illegally seized evidence. You're going to go figure on that one. So anyway. Extradition. Extradition takes place when an individual, for example, commits an offense in one jurisdiction and flees to another. I'll give you an example. I had a young man in one of my cases. In fact, it was one of my first very serious offenses. It was a double murder case. This individual committed the offense in Illinois, and he immediately took off, and they arrested him down in Texas at his grandmother's house, which is interesting because they will arrest somebody. Here in Chicago recently, we had a young man who was inadvertently released from prison when he should have been held in prison because they thought he had served time on another case, but that information was not given to them, that he had a more serious case, which was a murder trial that he still had to stand trial for and should not have been released. Well, this individual fled, and so they put an all-out bulletin looking out for him, and then they found him in Georgia. And so him being in Georgia, he can say, okay, I'll come back and stand charges, or I won't. But even if he doesn't mean that it's going to be a long process. Because of the Uniform Criminal Extradition Law, there are procedures. So he'll have due process rights, and then it's what we call basically a stay of execution, and he ends up being brought back, but going through some hoops that the police have to go through, or law enforcement has to go through in order to get him back to face the charges. So anyway, surrender a person from one jurisdiction to another, so they'll cross state lines. And then, now there are some countries, though, that persons go to, and if the crime that they committed subjects them to the possibility, even the possibility of the death penalty, they will not allow extradition, and that person is kept there. There was a young man by the name of Edward Snowden who I think he went to Russia, and they're protecting him. I think it's Russia. I'm almost sure it was. But anyway, it's not one of our friends or allies, and they're not going to let him come back here because he is involved in government secrets. So the United States does not have extradition treaties with all countries. That's what I was just saying a few minutes ago. And then, again, I commented about this already, that the European Union has repeatedly refused to extradite persons who would face the death penalty. So those are the kind of things. And then also persons who would face prosecution for criticizing a certain regime, such as the Chinese government, all these different types of things. Now, I'm not going to get too deep into this because this can get confusing. I remember when I was in law school, it was just, we had a hard time trying to understand it. However, it was funny because when we got out of law school, many of us, when we started practicing law, began to understand what was being said here. When I was in law school and I was at Northwestern and we were learning about joinder and severance of parties, it was presented to us in a fashion that we learned a lot of stuff very extensive, and sometimes it's very convoluted, very detailed, and deeper than it had to be. So anyway, prosecute defendants jointly or separately. So let's talk about separate trials. When does it have to be separate trial? Now, remember once again, in order to do this, it has to be multiple defendants. It's not multiple charges, it's multiple defendants. When the prosecutor uses evidence, for example, against one defendant in the trial, but it has not relevance to the other defendant, then in that case, there can be a request for a separate trial. I had a young man I represented who actually was charged with burglary, and that the individual was actually, when they arrested the individuals, he was unconscious in the back seat of the car, and it wasn't far away from where the burglary took place. And he had so much blood, so alcohol in his blood, that he could not have been a participant. So when it came time to try him, I moved, I filed what we call a Bruton motion to sever him from them, because my defense was separate from them, because my defense was going to be that my client was so inebriated that he didn't even have the capacity to commit burglary and did not participate in the burglary. That's contrary to what the defense for the other parties would have been, okay? So I was able to get a separate trial. So if there would be prejudice against one defendant, and you can see that if a jury was hearing a case about individuals who committed burglary, and my client who was, my allegation was that he was too drunk to have participated in the burglary, then in that case, then the jury or the trial of fact could hold that against my client, and he could get caught just from being in the crowd. So that's why it would be a prejudice issue against him, so it would allow me to have a separate trial. Inconsistent defenses, just what I said. One defendant is going to testify, but the other is not. It's another instance. Let's say if I decided in a case, and there were consistent defenses, even consistent, not inconsistent, and I decided my client's not going to testify. And if my client's not going to testify, and I make that clear up front in terms of a motion, then I could file and have a separate trial in that instance there. Joint trials involve each defendant receives a fair determination of guilt or innocence, and then their defenses and all of those are consistent, or all are either going to testify or not testify. And this is what I call the Bruton motion. That's why I called it that. It's named after this case, in which the Supreme Court held that if one defendant testifies and the other does not, defendants must be tried separately. Bruton and Evans were tried jointly for postal armed robbery. Excuse me. At the trial, a witness testified that Evans confessed that he and Bruton committed the robbery. The testimony was admissible for Evans because Evans confessed, but not Bruton's, because there would be hearsay otherwise. The testimony was inadmissible for Bruton because it was hearsay. So the bottom line, and if Bruton was going to not testify, which would be in that situation the best, then in that case, then he'd have a right to a separate trial and would have to be retried. Okay. So now it's a proactive motion. It's a motion that we always file. Now, there are a number of pretrial motions. I told you about this earlier. And remember, again, it is a pretrial, which means trial has not taken place, which speaks to the fact that a lot of people don't understand that from the time a person is charged, it could be some time before the case actually goes to trial, if it goes to trial. Now, we'll address that in a minute. Okay? Now, a motion to dismiss is one of the first motions that we use. You hardly ever get it. You can get the motion to dismiss. I have had successful motions to dismiss. I had a case where a young man was involved in a multiple defendant case. It was about 5 of them, and I represented the young man. And then the state presented witnesses and testified and provided evidence against everybody, but somehow or another, my client's name was never called. As long as I didn't hear his name called, I didn't ask any questions. My client was trying to get me, says, what are you going to do? I said, shut up. Will you shut up? So bottom line was what happened is that the state rested. At the end, they rested, and we were about to go to lunch. I said to the judge, Your Honor, I'd like to make a motion to dismiss. Justice On what basis? I says, because the state has rested and that my client's name was not mentioned anywhere in the evidence. I said his name was read when the names of the defendants were read, but no witness provided any evidence that even implicated or mentioned my client in it at all. So the judge said to the court reporter, could you do me a favor and take a lunch and go through the transcripts from this morning's hearing, which had taken about 2 or 3 hours, to determine whether or not what Mr. Wright is saying is true. So we came back after lunch, and I renewed my motion. The judge said, do you continue to persist with your motion? I said, yes, I do. And so anyway, the court reporter says his name was mentioned at the reading of the defendants and never anymore after that. And the judge says, okay, well, in that case, I'm going to grant Mr. Wright's motion. And the state jumped up and says, they object. And the judge says, what's your objection? Well, we do have information and evidence with this defendant, but, and this is what they said. It says, we missed it. We didn't have a chance, but we want to open our case again. The judge stood up from the bench. He said, fools. That's what he said to the attorneys, state's attorneys. You must be out of your mind. You're thinking, I'm going to reopen the case for you to do this. You had your chance. The motion is granted. Boom. Mr. So-and-so, you are dismissed. And so my client and I left out. That only happened that one time. But I'm just showing you how it can happen. But in all my years, the hundreds of cases that I tried, I never really had one. And most attorneys will tell you they don't really get them. But we still do them, even if we don't think we're going to get them. And the reason is because we're making a record. So that in the event that the appellate court or the appellate attorneys get it, in the event our clients are convicted, that they will have something to work with to possibly get a new trial or reverse a conviction, one of the two. A motion to determine the competency. We file motions to look at the mental state of the individuals as a general cause, depending on the kind of case it is. I had a young man who he murdered a young lady and raped her, and then hid her body, and he had never been in any trouble before, and so I made a motion to have him be examined by the psychiatrist. Well, that was a competency issue, and so they granted my motion, and the judge, the evaluation took place and came back, says no, at the time he committed the offense, he knew what he was doing, and it wasn't. So I had done my job. But, well, again, we try to do that. Then sometimes competency is used when an individual appears not to have the ability to be able to cooperate or assist counsel with providing information that can provide an adequate defense for that person. But anyway, that's one of the motions. And remember, this happens before the trial. Motion to suppress evidence. That is, what I talked about earlier, if there's some evidence that was illegally seized or obtained in violation of the Fourth Amendment search and seizure laws, or if there was a confession, which we talk about the motion to suppress confessions, admissions, was under coercion or duress, or either beaten out of a person. We've seen that happen in my time as an attorney. So we do file these motions, and then even if we're not successful, we file them. If you don't file them, and if you don't request, then you waive them, and you create a problem possibly for yourself as an attorney in terms of competency. But we have a little checklist, and we follow that checklist. Motion to suppress pretrial identification. Let's say, for example, if a person is identified in a lineup or either in what we call a show up. Let's say they brought this person back to the scene and so forth, and oftentimes we'll argue, well, this is the only person that you brought back. That's probably not good. And then also, we will also argue with photo, let's say you have photographs of individuals, and those individuals all don't fit the description, but just your guy fit the description. That we can file a motion to suppress it. And sometimes it's granted and sometimes it's not. Motion to disclose the identity of an informant. State might say that they want to protect an informant. We'll argue that we have a right to know who that informant is so that we can prepare our defense and that it denies us of due process and opportunity to adequately represent our client. That's just a short defense statement. Change the venue, that you can't get a fair trial in the area or where it's located. And then the standard motion for continuance, which speaks to the point of what I said earlier. Cases are continued oftentimes, and a person does have a right to a speedy trial. But what happens is when you as a defense attorney ask for a continuance, the clock stops. And if that continuance is for 60 days or 30 days, during that period, the clock doesn't run at all. And then it starts to run again. And then some other variables can happen. You could do it by agreement. And it's done because of the fact that we're, one of the initial stages in a criminal trial, once you get past the charges, is we file a motion for discovery. Now, that's not mentioned among there, but that's one of the motions that we file generally at the very beginning. Some jurisdictions call it motion for disclosure. And what it is that we are requesting, and it's really encompassing. It's a boilerplate document, very detailed, and covers every possible contingency known under the sun for the defense to be made available any information that the prosecution has, and then sometimes there's information that they have that's good information, and they'll withhold it. That can create a motion for a new trial or a ground for reversal. So we file what we call a motion for discovery or a motion for disclosure to get the evidence that the state has, reports, and access to witness lists, and all those kind of things as well. The arraignment is your first appearance in court. In that case, then the accused, as I say, enters a guilty or not guilty. The judge recites the facts, or you can plead guilty with the protestation of innocence. Usually it's guilty or not guilty, or nolo contendere, no contest. Again, in our jurisdiction, we have guilty or not guilty. Plea bargaining. Now, remember we're talking about pretrial. This first statement is very, very, very important, and you're going to see it now, and you're going to see it in the next session. Most of our cases, 90%, more than 90%, that means less than 10% of the cases go to trial. Plea bargaining involves where the defense and prosecution get together, they cut a deal, and it says quite clearly, a statement in point number 4 here, it says, without plea bargain, the system would collapse. If you are outside the system and don't understand the system, you might say, that's unfair. And the argument is that it forces a person to accept a plea. And the other argument is that it denies the victim's families a chance, or the victim justice or an opportunity for their issue to be addressed by the court. And so there are times when individuals plead guilty and it can come back and haunt them. Never in my years that I represent anybody did I force anybody to accept a plea. And so judges participate. And so let me give you an example of where plea bargaining, this is a good example right here. I had a young man. This is the same young man I talked about earlier when I said that he had committed a murder of a young lady. She was actually a meter maid and came to the house to cut the meter, cut the gas on in the city of Chicago. And he ended up being the only one home. He ended up raping her, and then he ended up murdering her. And so after I went through all of those list of motions and everything I could do, I reached a stage where it was apparent that this was going to not be a good thing if this goes to trial. I could foresee this young man, this young black kid, in a courtroom full of executives from Commonwealth, not Commonwealth, from People's Gas, filling up the courtroom, and also I could foresee that the evidence that was going to be presented was going to be very, very bloody. There were going to be pictures. There was going to be all kinds of things that would incite the jury. And I tried to suppress those, but wasn't successful. So I asked for what we call a 402 conference. At that time, it was Section 402 of the Criminal Code that you can ask for plea bargaining. So a pre-sentence report was ordered. And pre-sentence report is a process in which the probation department prepares a background of this individual, and is shared with me, the prosecution, the probation department, and the judge. That's who gets it. And the purpose for that is for us to see what kind of individual we're dealing with here. We already know the kind of offense, but we want to see what kind of individual. Well, it clearly demonstrated this individual didn't have any problems in school, and that he had no other contacts with the system. He'd never been in trouble. He was a regular attendee of church. He was a good citizen up to that point. So he was 17 when he committed the offense. At that time in Illinois, we had the death penalty, which meant that if he was 18 or over, he could qualify for the death penalty at that time, and he would have qualified for it. And so anyway, but because he committed the offense at 17, the worst sentence that he could get would be natural life. So what I did was I got the judge and to come to a decision based on all the evidence to award him, offer him 40 years. Now, at the time that he offered him 40 years meant 20. And there was a possibility that he could qualify for parole by knocking off maybe 5 years or something like that. So remember, at the time he committed so by this time he's 18. So I took the deal and I took it back to my client, and I met with his mother. He was 18 at the time, so he had the right to make the decision all his own. So I met with him and his mother and encouraged him that this was a good deal because he was 18, which meant even if he served the full term, he would be 38 when he came out. But there was a chance he could be 33 when he came out. Well, she said, well, I'm going to believe that God's going to deliver him. And I was, being a minister at that time, I wasn't a pastor. I told her that I understand what she's saying, but that I respectfully disagree because of the realities that were taking place here. I said, your son, if found guilty, when he leaves jail, he would leave with a tag on his toe, which meant that he's dead. So she said, I will take my chances. I said, well, okay, you're not taking chances. What do you think? And I asked the son, and he says, I'm going to go with my mother said. I said, okay. I says, I'm going to get back with you. So then I went to the other part of the building, and I had a statement typed out and prepared in writing, advising them of my recommendation, and advising them that my recommendation was to accept the plea, and they vehemently did not. Well, we did go to trial. We had a jury trial. I represented them. The jury was out 5 hours. I don't know, what they were doing, but they were out 5 hours. And of course, they came back to convict him, and he was found guilty. And the sentence was just what I said. He is now, at the present time, in prison, natural life. I can tell you this, that after I retired, he tried to pull, him and his mother, a post-trial motion saying that I didn't advise him of the deal, but I went back to my records and pulled out the letter and was brought back into court even after I retired, and the evidence was presented clearly that they did both sign the document. They both agreed that that was their signatures, and the rest is history. So then he asked me for DNA, because DNA didn't exist at that particular time. I told him, you don't want DNA, because DNA will nail you even more. So anyway, the bottom line is that I'm just showing you how that's an example of plea. I had other plea bargains, but most of the time I went to trial. I hear people all the time say, oh, I got a public defender. All they want me to do is plead. Well, once again, the point of the matter is public defenders are lawyers, but the system is such that you have a speedy trial in so many days, and it has to take place. So anyway, the bottom line is just what I said a few minutes ago, is that individuals find themselves pleading in 90% of the felony cases and cut deals, okay? The United States Supreme Court held in Broughton Kershaw versus Hayes that a defendant cannot be punished for refusing to plead guilty and choosing to go to trial. So, for example, Hayes was charged with uttering a forged document that's making some changes on it, and the prosecution threatened to re-indict him if he didn't plead guilty. Can't do that. He went to trial. The prosecution re-indicted him under the habitual offender law, and it was sentenced to life. The Supreme Court stated that this is a violation of due process. You can't do that. That way you're making the person accept the plea. You can't do that. You cannot do that. So that's what I'm saying, is that that's why I had that letter. I wasn't, and there are some people who say that the public defenders are making them. Well, they're not. They're presenting them the realities of what the case is. Prosecutors, as I already said, have wide discretion in whether to bring charges, what to charge, pursue, and what pleas to accept. Judges, on the other hand, once you get to the point, are constrained by their what we call mandatory sentences. And with mandatory sentences, there's what the statutes say, and the judges can't change that. What can change, though, if the charges are decreased, then that happens. But normally that doesn't take place. This is a fact. Minorities are more likely to be prosecuted and convicted of serious crimes than whites. What's this based on? Statistical data. The purpose of determinate sentencing, as what I said, when there's a certain amount that's determined for sure in advance, was to remove discretion and arbitrary decision. So, now, we get to pretrial discovery. I talked about this already, and I'm not going to spend a lot of time, but this goes to the motion that we file. But what it does, it allows the defense and prosecution to interrogate each other's witnesses and gain access to evidence prior to trial. As I said, there is a pretrial motion for discovery or disclosure filed, and it enhances the fairness of the trial. And as I said, exculpatory evidence must be disclosed. But it says the defense must request it. again, as I said, the all-encompassing discovery motion that we submit covers that information that the prosecution knows at the time or comes to know at a future time. And so the prosecution must then turn it over anyway. Prosecution may not knowingly allow perjured testimony as well. And they know somebody's going to commit perjury. They can't accept them as a witness. The discovery in the federal courts is more limited than in the state courts. Evidence given by a witness cannot be viewed before the witness has testified. This is kind of like when you deal in the federal courts. Then there are in camera. In camera means the judge reviews documents where the prosecution contends that they are not relevant to the subject matter to which the witness has testified. But there are limitations to discovery in federal courts. There's more liberal discovery in state courts. I didn't do a lot of federal cases because I used to see what happened. I worked with a couple of lawyers in federal cases. The Speedy Trial Act, no specified time, but the 6th and 14th Amendment, the indictment must come within 30 days of arrest, trial within 70 days of indictment. Now, again, there's various jurisdictions have various issues. The opportunity for trial must come, but it doesn't necessarily mean that that person doesn't have a speedy trial. Defendants can file a motion to dismiss if the time limits are violated. Exceptions when there are motions by a defense. I already told you about continuances and things like that. And states have similar rules based upon the time limits. Ours was 120 days in Illinois. Okay, and so anyway, that's more on that. So the speedy trial. So that's what covers pretrial. So now for the next few minutes, and it's pretty fast for me to go through, this is what happens. Okay, this is assuming that it's within the 10% or less than 10%, and it doesn't get disposed of by a plea. So then we actually have gone past all the motions in Chapter 18 that we had, and Chapter 17. And so now we come to the point that trial has been set and trial is going to take place. It's either going to be a bench trial where the judge hears the evidence or a jury trial. So that's where we are right now. So just so you get in your mind clear, the first part of this lecture involved pre-trial or before trial. Now we're talking about trial itself, okay? In another lecture that's going to come up, which we don't do, it involves post-trial. And I already told you this, less than 10% cases go to trial. They are disposed by plea bargaining. And there's trial by jury, and a jury consists of individuals or peers, and the juries would then have knowledge of the case. Well, now we pretty much want individuals who are fair and impartial. We even ask questions during voir dire, which we will address, where the individuals are questioned that are potential jurors about their knowledge about the case. Had they read anything or heard anything, and then determine what their propensity is before they're selected as jurors. Anyway, the Sixth Amendment right to a speedy trial and a public trial. Voir dire, on the other hand, can be closed, but not the actual trial itself. Limited or closed access may be necessary for rape victims because of the processes. There could be some in-camera information that's presented. Particularly when there are children involved, we want to protect children. Impartial juries, I already talked about that. You must be informed of the charges, and you have a right to confront your witnesses. And then effective assistance of counsel, and then self-representation with or without standby. There are some people who don't want standby at all, but the fact of the matter is most judges insist on standby counsel there, so that if a person starts to do something that's wrong, they will not. This young man, Dylan Roof, who was found guilty of murder in, I think it's South Carolina, Charleston. He is facing the death penalty, and he represented himself. And they had standby counsel, but the bottom line was he didn't want standby counsel, but standby counsel was still there because he's facing death because the jury voted that he is eligible for the death penalty. The right to an impartial jury, in which Scott Peterson was arrested for having killed his wife and unborn child. He was sentenced to death and received nationwide coverage, and the details of the case were well known across California. The judge changed the venue to another area instead of where he lived, but in the appeal, he still argued that the change of venue was not adequate to have an impartial jury because of extensive media coverage. Well, the fact of the matter is that it depends on what takes place as far as the media coverage is concerned, as to whether or not that person is going to be able to, where would they get a fair trial? Where would they have to go? In high-profile cases, can there be impartiality? You remember the O.J. Simpson case? That was a very, very high-profile case. There are many, many cases that Casey, I can't remember the name of Casey. We have an assignment in here about this case, but the individual down in Florida, you know, most of you know what I'm talking about down in Florida. Well, this individual was charged, and it was high profile. Well, there's a question about how that works. Now, you have a trial by jury, and I told you, juries don't extend to juveniles. I talked about that. Wright applies to cases where imprisonment is more than 6 months of imprisonment. An offender with multiple petty offenses is not entitled to a jury trial. Laws vary across states. Florida statute includes right for jury trial for all mala in se offenses. So pretty much any ones that you end up possibly going to jail, then you can have a jury trial. Jury selection under federal requires 12. Some state laws use a minimum of 6. However, in our cases in Illinois, 12 is the number, and then you have 2 alternates. And so basic qualifications is 18 years of age, registered voter, and are randomly selected by individuals. Says compensation is small, absolutely correct. You don't get much money. It is a duty, and if you don't serve and you're not excused, then you can end up being arrested. In fact, I've never been on a jury, but I actually have been subjected to jury duty, even as an attorney. And I remember one time I was in the jury box at our criminal courts building in Cook County, the main one, which is what we call 26 in California, the criminal courts building. And I came out with the jurors, and I was in the box, and the judge, he knew me because I had tried cases. He says, "Oh, what are you doing over there? You're not, lawyers aren't supposed to be." And I showed him my badge, and he says, "Stand up, Mr. Wright." He says, "Do you know me?" I said, "Yes, sir. We know each other very well." And then the attorneys for both sides, defense and prosecution, said, "Okay, get out of here," okay, and let me go. But I still had to go through the process. I think I got $20 or something. I don't remember what the heck it was, you know. So, but anyway, that's how juries work. And so you have a right to a bench trial or a jury trial. Voir dire, we already talked about that, in which the jurors are selected, and I already talked about challenges for cause. Examples: a close relationship with counsel, you know, language, barriers, opinion, so forth. Mine was relationship with counsel, judge, and everybody. Peremptory challenges, you don't have to give a reason, but there's a certain number that you have, and then you can't use it to stack the jury on the basis of race or gender. Okay, here's a case, 86 case, an example. The Supreme Court held that jurors may not be excluded from juries based on race. Now, excluded from juries. Get this. Rasmussen was an African-American, was tried for burglary. The prosecution struck all 4 African-American jurors using peremptory challenges. The court said Rasmussen did not receive a fair trial because it was purposeful exclusion of the black jurors. So you can't do that. You can't do that, okay? The death qualification of the jury. We have what we call a bifurcated process now, and that came about some time ago. If you ever read Furman versus Georgia, you'll see what I'm talking about. The death penalty is not unconstitutional, but there are bifurcated processes. In other words, what happens is individuals could be tried for the crime, and then the jury then has another hearing to determine whether or not the evidence that they heard was adequate enough for that person to receive the death penalty. And so that's what happens. But jurors who oppose the death penalty or have scruples of returning a verdict can be excluded from the jury. Opponents of capital punishment should only be excluded if they could make an impartial decision. And usually that question is asked, but it's pretty functional in terms of they end up not being on the jury. If the juror would prevent or substantially impair the performance of their duties as a juror in accordance with instructions or oath, then they could be disqualified, particularly in a death penalty case. They don't want anybody in there who would be predisposed or biased. In Rivera versus Illinois, a 2009 case, Supreme Court held that the trial judge's erroneous denial of the defendant's peremptory challenge did not constitute an error. They call that harmless error. Rivera's attorney submitted a peremptory challenge, but the judge denied that peremptory challenge. The court held that this was an error by judge, but they call it harmless error. It is a phrase that you will hear constantly if you ever read appellate court decisions, that there are errors. Again, this gets to something that we as defense attorneys, it makes the hair stand up on our necks, is that you're telling me that a person must be found guilty beyond a reasonable doubt, but that you're going to allow error and then label it harmless error. How do you know that it's actually harmless? Well, it's based upon the judge's or the court's decision. That's problematic for us. And prosecution don't care. Of course not. Okay, we talked about jurors may not discuss the case with anyone. O.J. Simpson case where the jurors were sequestered. They were actually forced to stay together. They had whatever they read, reviewed, and then protecting jurors from cameras not being allowed. Now cameras are coming into courtrooms now. The gag order is an order where the court issues an order telling all parties, attorneys, witnesses, not to talk to anybody, including the press, about the case itself. Now, here's a case that goes back to something we were talking about earlier. Remember the Scott Peterson case? But here, look at what happened here. Remember, he said he couldn't get a fair trial. But let's look what happened with Shepard versus Maxwell, which is a different disposition. The Supreme Court held that intense media coverage of a case may prejudice the jury, and so the jury in violation of due process. And they actually did a movie about this. There was a TV show used to come on called Petrocelli years ago, and I can't think of the guy that played the role, but then it was defense attorney. But they did a movie that was based upon this actual case, the Sam Shepard case. Sam Shepard was convicted of murdering his wife, and he was a physician, and it argued that the jury was greatly influenced by intense media coverage. The court overturned the conviction. Shepard was found not guilty on retrial. Well, his son filed a civil lawsuit against the state of Illinois claiming that his father was wrongfully incarcerated all that time, but the claim was rejected by the jury. The fact of the matter is that even if he was found not guilty the second time, you couldn't come back with a civil suit saying he was wrongfully incarcerated. That would be a floodgates situation. You'd have a whole lot of people in that status. But anyway, the key thing here was that and if you just seen this, it was like a circus. But the jury was able to see all of this. I think this was in, I don't remember where the case itself was in Arizona or someplace like that. But anyway, wherever it took place, the media had a field day there, and the man couldn't get a fair trial. So anyway, when he did get a fair trial, he was found not guilty. In Nebraska Supreme Court, the Nebraska Supreme Court held that a gag order is constitutional. I already talked about that. Trial court imposed a gag order in which ordered that the parties not talk. The trial received much attention, news, and the judge imposed a gag order to protect the jury. Well, the Associated Press, who wanted to talk to them, argued that the gag order violated the First Amendment. Supreme Court says, nope, not so. The Supreme Court. And so as a result, the bottom line is that no, this is not a violation of the law. It's for protection to give an individual opportunity to have a fair trial. And that is premier over that issue. Judges have to have control in their courtroom. They have to make sure that they deal with unruly defendants. They have the right to issue contempt citations, and this takes place a lot in political trials, but it can happen in Casey Anthony. That was the case I couldn't think of earlier. We had an exercise in the class about that. A person can be removed from the courtroom for that. I remember years ago, I was at a federal court, and there was a case that involved a Panther and some people that were radicals back in the 60s. They called them the Weathermen. Had nothing to do with the weather. That was just the name of the organization. And one of the parties had to be gagged in the courtroom, tied to the chair, and had to be ultimately removed to keep the court under control. Behavior of counsel. There are guidelines and ethics that may not express personal opinion or inflame the jury, and the lawyer can be disciplined by the Bar Association or reprimanded or found in contempt by the judge. The key thing is that the judge has the power to protect the opportunity for the individual to receive a fair trial. Rules of evidence are what regulates what is considered in the trial. Remember I was talking about earlier about my client that they mentioned his name and I was able to get the motion to dismiss. Well, the reason why I was able to get the motion to dismiss is that there was not a bit of evidence. Evidence consists of the following: verbal statements, writings, documents, photographs, tangible items that prove or disprove some fact. None of that exists, then it's not. Evidence is based on what comes from the witness stand and what is allowed as the judge exhibits that are admitted into evidence. Hearsay is not, except there's some what we call rules of exception. I'm not going to get into those because those are very, very intense. I teach a course on evidence, and when I teach that, I go into those things. The court takes judicial notice of what evidence is, and proof, a standard, is beyond a reasonable doubt, and all evidence must be relevant to the charges. This continues. Similar fact evidence refers to facts similar to the facts. Prior crimes may be admitted. Now, the way that prior crimes get admitted is if the defendant takes the stand. They can use the prior crimes to what we call impeach that individual, or to show that that individual has demonstrated propensity to commit crimes, and those kinds of things. Classification of evidence in cases are what we call real evidence. That's something you put your hands on, as opposed to evidence that is not tangible. Direct evidence that goes directly to the charges. Indirect evidence, which creates a inference of what may be taking place. Eyewitness testimony. Eyewitness testimony is considered as very unreliable. My professor, when I was in law school, did an experiment with us unbeknownst to us early on in our classes, where we were sitting in a big auditorium. There were probably about 60 of us in there, and he was lecturing, and then all of a sudden, some guy ran in there, grabbed his wallet, and ran out. And we were like, oh, wow. But everybody realized quickly, because the professor says, take out a piece of your legal pad and write down a description of that individual. And then we were able to share our descriptions, and they were so varied because it was very quick. If you saw the movie My Cousin Vinny, you saw how the defense attorney used and impeached the individuals on the ability to be able to observe based on eyewitness testimony. It is considered as one of the most unreliable forms of testimony, and a good lawyer can take it apart. Circumstantial evidence is evidence that indirectly points to the person innocent, or guilt, rather. Okay. Expert witnesses, forensic experts, medical experts, handwriting experts. They must be voir dire. Now, listen to me. There's a difference in what I was talking about voir dire earlier. Voir dire in this case is to question them about their credentials and their ability to be able to consider themselves as experts. They're subject to cross-examination, and hypothetical questions may be asked of them. The ordinary witnesses, you can't ask hypothetical questions, but the expert you can ask. And I can tell you that forensic and medical experts are really good. I won a criminal case because of the medical examiner's testimony and the cause of death based on the medical examiner. Very quickly, what happened is I had the young man, same one I told you took off to go to Texas. He, when he shot, he was closing the door, let these guys in to a crap game. And when he turned around to head up the stairs to the level where the, which was only about 6 or 7 steps, they were at the top announcing they were robbing the place. Well, anyway, he ended up getting his gun out, and they turned to him, and he fired shots at both of them, and they went down. Then he came up the stairs and emptied his guns by shooting them in the back. Well, the fact of the matter is, like I said, he took off. And so anyway, I did some real serious research, and I asked him, based on what he told me, I said, well, we might have a possible self-defense, but we got a problem here because you shot him in the back. That's not consistent with self-defense. So anyway, I said, we're going to come up with something. So when I requested the medical examiner's report, I discovered something in the medical examiner's report that the cause of death was from a single shot that was fired consistent with a person who was squatting down, and the shots were fired up, and the individuals were facing the my client who fired the shots at both of them. Therefore, the evidence showed from the report, and that the expert testified, that the cause of death was that single shot. I said, well, what about the shots that were in his back? I already knew what the answer was going to be. He said they were already dead. And so I said, so they were dead based upon the fact that they were facing him and he shot? Yeah, he was a good shot at both of them. The shots that he had fired in the back were superfluous. It looked bad, but the testimony of that expert was the key that just sunk my prosecution's case and gave me a victory in the case, along with some other things. So that can be good. And then these are some examples of expert witnesses. Scientific evidence is now really, really, really good. Evidence obtained through scientific and technological innovations, innovation of the Wright test, or the polygraph evidence. There's some issues that can be argued because you can present witnesses that are experts about the reliable or unreliability of that. Hypnosis is also, there are people who actually are able to testify that people are enhanced in their testimony. And experts in the battered women syndrome, the scientific evidence that comes about that can be argued that battered women syndrome can be used as a defense in a domestic violence case where a person defends themselves and murders and kills a person. And then the all-encompassing, that did not exist when I started, but came about near the end, was the DNA evidence. That is the most revolutionary evidence that came about from a scientific nature that has resulted in the exoneration of many innocent parties, and it is an exciting concept as well. So now in the times that you guys are in now, you're familiar with the DNA. Okay. In court cases, there are objections that we raise in court. You hear attorneys say, objection. Well, there's what we call a general objection, which is against the witness or testimony and evidence. And then there's specific evidence that you object to, such as hearsay, testimony by a witness as to facts that the witness heard from another and they try to use. Then the judge should sustain that. When you hear the word sustain, that means that your objection has been granted. If it is overruled, then it speaks for itself. Then there are some objections saying, wait a minute, the evidence that's being presented is not the best evidence, or it is the best evidence, primary evidence used to prove the facts. And then other objections are that the question that a person might ask calls for an opinion. Testimony must be based on facts, with the exception, remember what I said, is that opinions can be used with witness experts, okay? Okay, you're not going to go into that Crawford case. Well, I will. Supreme Court held that in all criminal prosecutions, the accused shall enjoy the right to be confronted with witnesses against him. So in this case, the prosecutor introduced a recorded statement from his wife in which she stated that he did not act in self-defense. Well, Crawford appealed, arguing that the pre-recorded statement violated his right to confront witnesses against him. So that person had to come in so they can have a chance to question that individual, not just use that testimony. Okay. If that person was still available. Now, there are some other rules that I won't go into. Near the end here, we get to what we call privileged communication. That means that attorney and client are free to discuss cases, and that the attorney cannot discuss this, cannot be forced to provide the information. The client can, though, waive the privilege, but the attorney cannot, unless the individual passes away. Then in that case, the attorney-client privilege is gone. Marriage, we don't want husbands and wives being forced to testify to preserve domestic harmony in the situation. Of course, though, if it's a case where there are opponents or either where there's domestic violence involved, then that's a different situation. Clergy, same thing, priests, ministers. Now, people have to be very careful about some of these types of things, that if they admit to crimes that have nothing to do with what the charge is here about, then in that case, that's not privileged. Doctor-patient privilege as well, same kind of thing. Because the key thing is to promote an open dialogue between the doctor and patient, the clergy, and the members themselves, and then, as I said, to protect marriages. Okay. Mechanics of the criminal trial. The judge is like the umpire. They rule on motions, instruct the jury, have wide discretion, but then they can be reversed by the appellate court. Opening statements are things where you give a synopsis of your case, your outline, your theories, and so forth, and the defense can defer opening statements. Defense and prosecution give opening statements at the beginning of a trial. That is not evidence. Keep in mind, that is not evidence. Each side has a right to call witnesses, and I already talked about lay witnesses versus expert witnesses. Right to cross-examine the witnesses. Leading questions cannot be asked by of your own witness. So a defense attorney can't put on a witness of theirs and then ask leading questions. That's going to be objected to. Same thing with the prosecution. Witness may be subject to impeachment, which means they can be caught either in a lie or not with the ability to be able to accurately present the truth, such as eyewitness testimony proving that a person could not have seen, could not have observed, or that they gave the wrong description of the individual. Then there are child shield statutes that do protect children in terms of courts. Defense can move for what we call directed verdict of acquittal. Again, that can come about after a person, they go through the state's case like what I did and got the individual dismissed. Now, remember, the motion can be filed early on if you don't think the evidence is adequate enough that the state has to present a trial. That's hardly ever granted. But directed verdict is closely to akin as to what I ended up getting when I got that young man I was talking about earlier, where there was no evidence against him when the state rested. Okay, and then defendant has a right not to take the stand. But again, when they take the stand, they're open to cross-examination by the prosecution. And as I said, prior crimes that can be brought up. Rebuttal witnesses. These are witnesses who, at the end of the case, it appears that the state has some person who can present something different from what the defense has provided to rebut what they presented. I've had a few of those, not a lot, but one that sticks out in my mind is I had a case one, and an individual, I had told him when he was in custody not to talk to anybody while he was in prison or in jail awaiting trial. Well, at the end of the case, the state had a surprise rebuttal witness, and they gave us the information on what that person was going to say and what their name was. So I discussed it with my client. He said, I don't know. So anyway, and they had his name, and the client didn't recognize his name. So the next day, the witness comes out, and my client looks up and he says, he started mumbling the expletive. I said, what's the problem? I said, Your Honor, may I have a brief recess? He said, 5 minutes. I took 5 minutes to talk to my client. Turned out that this was somebody he had told some stuff to, but he didn't know his real name. And he said, that's not how the guy looked in jail. They got him all looking clean and innocent. Well, the bottom line was his testimony convicted my client as a rebuttal witness and just shot my case out of the water. And that's what rebuttal witnesses are intended to do. The conduct of the jury. They listen to the evidence. The judge can allow questions for witnesses. Then there are closing arguments where there's a summary of the case itself. Following that, the judge issues to the jury, this assumes a jury trial, jury instructions, which explains legal terms. And usually the instructions are boilerplate. Illinois has what we call the Illinois pattern of jury instructions. Those are given based upon the elements of the charges, and they're given to the jurors, and they can take them in the jury room. But it instructs them as to what the law is and so forth. The judge does not summarize the evidence or give an opinion of the case. He just gives what the law is from there. Jury deliberates, and when the jury deliberates, their first job is to select a foreperson. The foreperson is the person who is basically what we call the chairman of the jury. And then their deliberations are secret. They are protected from anybody. If there is a deadlock in the jury cannot agree on a verdict. Now, a deadlock doesn't have to be 6-6. It could be 11-1. And then there's an Allen charge that takes place, and the judge can request not for anybody else, but for their own as to how far they are. They said, well, it's 11-1. Well, then the jury will tell them to continue deliberating. And then if at the end it comes out that they can't, they're hopelessly deadlocked. They're not going to, because it requires a unanimous verdict. It can happen. My daughter, for example, was on the jury. How she got on, I don't know, in a criminal case. And she hung the jury. It was 11-1. And she was strong enough to refuse to change her position no matter what. She had a lot of pressure put on her. And it was after the judge ordered continued deliberation. They were hopelessly deadlocked, came out, asked the jurors whether that was their verdict, their vote, and my daughter said, yes, I find him not guilty. Well, they had ordered a new trial, and the jury was tried with another jury, and by the way, he was found not guilty. So maybe she was right. There are jury pardons, in which jurors are excused from the jury, or let's say the judge finds that the jury did something wrong. That happened in the O.J. Simpson case. There were individuals who did things wrong, and they were removed from the panel. Jury finds defendant not guilty, despite the evidence. Very rarely happens, but there are some instances where the judge can step in and say that we call them judgment. The judgment comes in notwithstanding the verdict, where the judge's decision overrules the jury's. Very rarely happens. The O.J. Simpson case, we talked about that, was extensively covered. The media and members were sequestered for 9 months, and then this told the rules that they were. So there are some arguments about sequestered jurors, that they're also under pressure to reach a decision, but you know what happened there in that case. Then finally, we're at the end. There is a written verdict that's issued. The jury is then polled, and what that means is each juror is asked in open court, is this your verdict? And they say yes, and so forth and so on. That's what I was talking about earlier. Then, assuming the person is found guilty, then there are post-trial motions, a motion for a new trial. That's usually just a standard motion to perfect for appeal, alleging that errors were committed at trial, usually denied. And then from that point on, then you have usually in our jurisdiction 30 days in which to file a notice of appeal, which is generally done right away to perfect your appeal rights. And then it goes to the appellate process. Remember, that again only applies to a person found guilty. And that's it for tonight. I want to pass on this information to you, and so you will be getting this. And I wanted to take the time to wish you the best. I hope you had a good quarter. If it appears that you didn't have as good a quarter, I'm sorry. I offer every opportunity. Of course, there are some things I don't have control over, and then there are some things you don't have control over. But as I said from day one, my goal was to get you across and to get you in the AB category. And I'm pretty successful with that. My percentage is very high on that. And there are sometimes people have to take me again, but not because of anything that I did, but they understand the situation. So I'm going to say good night. And if you need to reach out to me during week 11, you know how to do that. Good night.